The prompt for today is, for today's Counterpoint webinar, is what are the limits of religious liberty? This is the 5th Counterpoint webinar of the year, and we are lucky to have two very distinguished speakers with us, David French of the National Review Institute and Professor Linda McClain of Boston University School of Law. The order of operations today is very straightforward. Mr. French will speak first for about 20 to 25 minutes, and then Professor McClain will speak second for about 20 to 25 minutes. And then we'll simply move to questions from the audience until about 6:15, as usual. So I will begin actually by introducing Mr. French, and then I will hold my full introduction for Professor McClain until just before she speaks. David French is a name that may be familiar to many of you. He is a fellow at the National Review Institute and editor at The Dispatch. Previously, he served as president of the Foundation for Individual Rights in Education, FIRE, and as a senior attorney for the American Center for Law and Justice and the Alliance Defending Freedom, where he specialized in religious liberty cases. He also worked as a staff writer at National Review, Time, and during the Trump era, Mr. French became nationally known as a leading conservative voice in the Never Trump movement. As we were discussing just before, there is even an ism connected to his name, David French-ism, known in some quarters. I sometimes tell my students, you know you've made it when you not only have an ism connected to your name, but when there are left and right versions of that ism. So something to aspire to. He's author of 4 books, including most recently in 2020, Divided We Fall, America's Secession Threat and How to Restore Our Nation. A veteran of Operation Iraqi Freedom, Mr. French was deployed in Iraq in 2007 and was awarded a Bronze Star. He is a graduate of Harvard Law School, and it is a pleasure to welcome him to virtual Middlebury.
Well, thanks so much for having me, and I'm hopeful we're nearing the end of the virtual part of all of these kinds of events. I'm looking forward to actually being around people again. I just had the second shot, and aside from lobster claws and x-ray vision, I have had no negative side effects. It's great to begin to reemerge. I'm going to talk about religious liberty. I'm going to talk about why it's valuable, why, in fact, I think it's not just valuable, but necessary for our functioning constitutional republic, and where I think the law of religious liberty is and where it should be. How close are we right now to where the law of religious liberty should be? What should be the state of the law? So to go forward to what it should be, I'm going to have to go back. I'm going to go back to the beginning of the republic. We all know, and anybody with any familiarity with American history knows, that the founding of the United States, when we're talking about the values of the founding, whether it's the inalienable rights of the defense of unalienable rights of life, liberty, and the pursuit of happiness, to the enactment of the Bill of Rights, that to a large degree, this was aspirational. These were rights that were being introduced and recognized in a society that in many ways was quite far, very far from protecting them broadly in society. In fact, some people, as we know, enjoyed none of the rights of the Bill of Rights, none of them at all. But when we're talking about the aspirations of the American founding, what you're talking about is creating a small L liberal democracy that preserved and protected certain values. And when I think of the Bill of Rights, I think of the Bill of Rights as sort of the fundamental. If you're going to talk about the American founding, you've got the mission statement, which is the Declaration of Independence. It has its sweeping language. We hold these truths to be self-evident. We're endowed by our Creator with certain unalienable rights. Among them are life, liberty, and the pursuit of happiness. And it goes on to say that governments are instituted among men to preserve these liberties. But the Declaration of Independence wasn't a legally binding document. It was, to the extent it had any real force and effect, it's a declaration of separation from the British Empire. So it was more like a mission statement. It was more like, if you're talking about a corporation and its mission statement, they don't really mean anything other than as a statement of moral purpose, a declaration of moral purpose. For this moral purpose to mean anything, you got to have laws. You have to have laws. So what does life, liberty, and the pursuit of happiness mean in a very real legal sense? Well, when the Constitution was drafted, there was, and this is just sort of basic stuff, and the Constitution was drafted, there was a lot of people who thought that the Constitution itself, without any amendments, was just fine for articulating rights, in the sense that it was a constitution of enumerated powers. The federal government had only the powers that were given to it by the text of the Constitution. The rest of liberty was sort of left to the people. If the government had only the power that was granted to it explicitly, well, then everything else rests with the states and with the people. But there were a lot of smart folks who said, no, wait a minute. We need to articulate more clearly what are the fundamental rights of American citizenship, of belonging in this American democracy. And that's the Bill of Rights. The Bill of Rights, which passed the first 10 amendments. This is where the founding fathers started to say, to articulate in a very clear, simple fashion, these are some of the fundamental rights. This is sort of the fundamental American social compact. Now, again, we'll go back and note it's aspirational at this point. It is not actual. There's entire populations that do not enjoy full access to the Bill of Rights. American slaves did not enjoy any access to the Bill of Rights at all. But here are these sort of fundamental values. This is what it means. This is what the American Republic aspires to in a legal sense. And so these are values that often we think of, and we almost, they're such secondhand to us that we often wrongly take them for granted. Free speech. The founding fathers put their thumb on the scales and the political struggles towards free speech. It's going to be very difficult for any government, whether it's federal initially or after the Civil War amendments were passed, state or local, to overcome your inherent right, your constitutionally protected right of free speech. Here's another one that's critically important. Due process. Due process. Again, putting the thumb on the scales to say, here's a fundamental aspect of what it means to be an American, is you're going to enjoy due process. Before your life can be taken, before your liberty can be taken, before your property can be taken by the government, you're going to have due process. Freedoms from cruel and unusual punishment, freedoms from unreasonable search and seizure, freedom of the press, freedom of assembly. All of these things are fundamental, core, foundational parts of the American social compact. There's another one, free exercise of religion, free exercise of religion. Now, why would that be included when you had a lot of other rights that were included within the Bill of Rights that, if you're going to draw a Venn diagram, overlap a great deal with free exercise of religion? So, for example, free speech overlaps a great deal with free exercise of religion. Why would you carve that out specifically? Well, if you go back and if you look at the American founding, it's looking at it in 21st century eyes, it doesn't seem very diverse. It's not something that it doesn't scream diversity, because you're talking about the American Republic put together largely by white Christian males, mostly Anglo-Saxon background, doesn't seem super diverse. But if you go down the eastern seaboard of the United States of America, you're going to see something interesting. You're going to see Puritans in Massachusetts. You're going to see in Rhode Island people who fled the Puritans in Massachusetts. You're going to see Quakers in Pennsylvania. You're going to see Catholics in Maryland. You're going to have a lot of Anglicans in Virginia. When you go and you look at all of these various theologies and different in competing religious belief systems, and modernized, we go, oh, well, it's all just various brands of Christianity. I can see all those brands of Christianity just driving down the street in any given southern town. But if you're looking at it in 18th century eyes, you're not that far removed from the 17th century, when those were the brands of Christianity that fought the most deadly wars in European history to that time. In fact, the wars of religion were the deadliest wars and the most vicious wars in Europe, arguably, certainly until the Napoleonic Wars, and arguably until World War I. It was far from certain that all of these competing groups could live together. That because there wasn't a lot of track record, quite frankly, that these competing religious groups could live together. So there were two aspects that allowed these sort of groups to bond together in one nation. One is the Free Exercise Clause, which gave me rights against the state to say, I'm going to have a default right of free exercise of my religion, and an Establishment Clause that said the state can't establish a religion in the same way that the British Empire, for example, established the Anglican faith. And these two elements of the First Amendment, the religion clauses of the First Amendment, just as the early republic put the thumb on the scales in support of due process, against unreasonable search and seizure, in support of free speech, it puts the thumb on the scales in the supreme law of land for free exercise of religion. All right. And this is something that I think the importance of this has been borne out throughout American history. Because what is the free exercise of religion? In a lot of ways, what the free exercise of religion is, it's the ability to think, speak, and act in accordance with your deepest beliefs. Think, speak, and act in accordance to your deepest beliefs. This is because free exercise of religion has been extended to both theistic and to atheistic worldviews. It's your ultimate belief system. It's to think, speak, and act in accordance with your ultimate beliefs. And this is foundational in many ways to our republic. Now, it does not mean that free exercise of religion is unlimited. And in fact, what we've often done throughout American history is confuse Christian liberty with Christian power. There have been many points in American history when, for example, white Protestants exercised an enormous amount of power. For example, Prohibition was a movement driven largely by the power of white Protestants. That doesn't mean that there was liberty, because at the same time that there was this move towards Prohibition, there were a bunch of anti-Catholic state constitutional amendments, explicitly anti-Catholic, passing in states across the country called Blaine Amendments. There's a difference between religious liberty, which is a freedom you exercise against the state, and religious power, which is often the power of religion exercised through the state. And what we've begun to migrate to in America right now is a regime not so much of religious power, where one religious point of view exercises power, but we're moving towards a regime of religious liberty, where people of all faiths are enjoying, to a large degree, an equal amount of liberty, regardless of what the power structure is seeking to suppress the exercise of their faith. And I think that this is something that is critical to the functioning of a republic that is increasingly multi-faith, multi-ethnic, increasingly ideologically diverse. How do we all live together in a culture where we're going to have increasingly divergent worldviews, increasingly divergent belief systems, and about ultimate truth? And that's where I think religious liberty isn't just an important value, it becomes a critical value. It's a way in which a pluralistic society can function, by giving people of different faiths their own spaces where they can live out, again, think, speak, act in accordance with their deepest beliefs. And what we're moving towards is a legal regime that has some pretty salient characteristics. One is religious people are going to be protected in the workplace. In other words, if you're a person of a particular faith, you're going to have the right to be considered for a job and hired and promoted without regard to your underlying theology, whether it's atheistic, theistic, or otherwise. That if you have a religious institution that you're a part of, that you belong to, you're largely going to be able to run that religious institution in a manner that is consistent with the dictates of your faith. All forms of religion are generally going to have equal access to federal funds that are dispensed for non-religious purposes. You're beginning to see what's happening here. We're beginning to move towards a legal regime that essentially treats all religions equally, treats religious individuals equally with non-religious individuals, and grants to religious institutions a high degree of autonomy to govern themselves according to their religious points of view, at the same time that in secular spaces, religious individuals are treated equally but not favored. Not favored. So, for example, in non-discrimination law right now, federal non-discrimination law, after a decision called Bostock, protects people from discrimination on the basis of race, sex, religion, or LGBT status. So all of these different classes of employees are coming into the secular workplace equally. But in a religious space, the religious institutions are increasingly left alone. So that's where we're moving right now as a matter of legal doctrine. And I think that what we're doing as we're moving towards that legal doctrine is we're beginning to finally start to realize the aspirations of the founders, which is, how is it that we guarantee to all Americans these very basic civil rights, these very basic civil liberties? And it's by respecting our own ability to think, act, and speak in accordance to our deepest beliefs, to respect the autonomy of religious organizations that embody those beliefs, while at the same time in secular spaces, treating religious and non-religious people equally as they access government benefits, as they access the secular workspace. And I think we're moving, hopefully, towards I'm not going to say resolution to the religious liberty culture wars, but moving towards stability in the religious liberty culture wars along those lines. So that's the opening. That's why religious liberty is valuable, why it's necessary from the founding of our republic to knit us together, and why I think we might be moving to a place where there's a degree of stability, at least in this aspect of the culture war. So I look forward to hearing Professor McClain disagree.
Thanks so much, Mr. French. I'll offer an introduction now for Professor McClain, who is Robert B. Kent Professor of Law at Boston University School of Law. She is known for her work in family law, gender and law, and feminist legal theory. Her scholarship addresses, in particular, the respective roles of families, institutions of civil society, and government in fostering citizens' capacity for democratic and personal self-government. Professor McClain also coordinates the law school's participation in the Women's Gender and Sexuality Studies Certificate Program, and she served as a faculty fellow at the Boston University School of Theology. Her 7 books include Who's the Bigot? Learning from Conflicts Over Marriage and Civil Rights, Gay Rights and the Constitution, and Ordered Liberty, Rights, Responsibilities, and Virtues. Professor McClain has held visiting fellowships at Harvard University, Princeton University, the University of Virginia, and Penn. A graduate of Georgetown and NYU law schools, she also earned a degree in religious studies from the University of Chicago Divinity School. It's a pleasure to welcome Professor McClain to Virtual Middlebury.
And since we're at Middlebury College, I have to do a shout out to my alma mater, Oberlin College. So, okay. I actually agree with much of what Mr. French has just said. And I'm particularly struck by his spatial imagery, because I think part of the conflict over the scope of religious liberty is how to envision these spaces that are shared spaces where many people are interacting. And Mr. French has talked about secular spaces and religious spaces and said that in secular spaces, religious individuals are treated equally. But part of the issues we have right now is, say you have a business owner who is running a business like a deli or a grocery or a cake, a bakery or whatever, and they have religious convictions and they want to live out their religious faith in their business. That's where we get into some issues when those convictions may come into conflict with state anti-discrimination law, which says if you open your business to the public, you are a public accommodation and you can't turn people away based on a set of protected categories, typically race, color, national origin, religion, sex, and in about 20 or 21 states, sexual orientation. So in states that have that particular area, we come into conflict with merchants who say they're religious belief forbids them to recognize in any way same-sex marriage as a marriage, and therefore they can't bake a cake or photograph a ceremony or prepare stationery or what have you. But I want to kind of back up now, and so I'd be interested to hear, I know what Mr. French has said in print about this, but I'd be interested to hear how you define secular space, and if it includes business people who have religious convictions and want to live out their faith through everything they do in their business, like maybe not give benefits to a same-sex, to an employee who has a same-sex spouse, or not pay for contraception, not support healthcare that includes contraception and the like. Anyway, so let me just back up though and talk about my approach to these issues. And David was so economical with his time. If I start to run over, please someone send me a nasty message in chat. I'm looking at my phone here and I'll try to discipline myself. Okay, so first of all, I want to thank you for including me in this forum. I really appreciate the model of having thoughtful disagreement. It's so important right now at times of extreme political polarization. So when I think about the question of what are the limits of religious liberty, I think it's helpful to step back and consider the relationship between religion and the state. And I have written in some of my prior writing that we could think about this as in terms of congruence on the one hand and conflict on the other. There's an assumption, and both of these ideas are sort of prevalent when you think about what it means to be a constitutional democracy. There is this one idea that religious institutions are seedbeds of civic virtue. They're an important site where dispositions and values and virtues are nurtured, and those are like a bedrock for the republic that we depend. The family is also thought to be another seedbed of virtue. So the congruence idea is that religious institutions sort of inculcate values in their members that make them good citizens. So there's a congruence or connection between the state and religion, a harmony, if you will. But there's an equally important idea, which is that religious institutions are sites of authority for their members, and they may have teachings and principles that are contrary to that of the state. And in fact, they're kind of bulwarks of liberty where people can inculcate values and virtues that may not be in congruence with the state, right? So these are both important ideas, congruence and conflict. And by protecting free exercise, right, and coupling that with the Establishment Clause, we say there's not going to be a state-sponsored religion, and that, as George Washington said to the Hebrew congregation of Newport, happily the U.S. gives to bigotry no sanction and to persecution no assistance, and that means that people should not be persecuted by the government because of their religion, right? Okay. So when you think about some of the present-day controversies over religious liberty, some of it has to do with this uneasy tension between congruence and conflict. And I'm going to use the example of marriage because so many of these highly visible controversies have involved marriage equality. And when I say marriage equality, I mean the proposition that same-sex couples are entitled to marry under civil law all across the United States, based on Obergefell and before it, a number of state court decisions and state laws. So the late family law scholar, I'm just going to read a short passage here. The late family law scholar Lee Teitelbaum once remarked that for most of American history, the law of marriage was consistent with and supported, if not created, by the views of dominant religious communities. For example, in the middle of the 20th century, the Catholic Church view that artificial contraception is immoral was enforced or supported by law in some states. Their notion that, but on the other hand, there's also quite a difference between civil marriage and some conceptions of religious marriage. The adoption of no-fault divorce, obviously, was quite a departure from the views of some religious traditions, either about the permanence of marriage or the very limited grounds on which one should be able to end a marriage. The move away from the notion of hierarchical roles in marriage where the husband's the head of the household, the wife sort of has a duty of obedience, and that mother and father are extremely differentiated gender complementary roles. Civil law has moved away from that, partly because of the so-called equal protection revolution that Ruth Bader Ginsburg helped to pioneer in the 1970s, so that spousal roles are gender neutral. We no longer have a hierarchy of husband and wife. We no longer think fathers and mothers should be treated differently within marriage in terms of the custody of their children. The states have also repealed criminal laws that punish non-marital sex, including gay sex or non-marital cohabitation. We have laws permitting people to use reproductive technology to conceive children, when this we know is contrary to some religious teaching. So we don't exactly have congruence between civil and religious ideas about marriage and family. In the same-sex marriage debate, some religious conservatives argued that allowing same-sex marriage would be the final nail in the coffin of moving away from understanding marriage as a permanent union based on sexual union of one man and one woman and a special gender complementarity. I was very interested in Mr. French's discussion of Christian power versus Christian liberty, because I would argue that back in 1996, when Congress enacted the Defense of Marriage Act, and I don't know what he thinks about this, this was an exercise of Christian power. Because they thought Hawaii might be legalizing same-sex marriage, Congress enacted something called the Defense of Marriage Act, which was to say that for federal law, marriage is only the union of one man and one woman, and that no state had to recognize another state's out of same-sex marriages, right? And some of the language of DOMA was the view that moral approval of heterosexuality better comports with traditional, especially Judeo-Christian morality. And in addition to DOMA, there was also an effort to pass a federal marriage amendment, which was unsuccessful. And the sponsors of that act insisted that heterosexual marriage reflected God's created order. So you see how, this attempt to use kind of religious conceptions of marriage in civil law in a way that would keep people who had been excluded from marriage law to be able to be included into it. And I just have one, when New York passed the Marriage Equality Act in 2011, Archbishop Dolan really condemned it and said that God, not Albany, settled the definition of marriage a long time ago. And basically that a law that purported to redefine marriage in a way that was inconsistent with God's law was not a law. So there was this notion that somehow there couldn't be this gap between civil and religious law. So anyway, so many of the debates in the last decade or so have arisen concerning marriage equality, and I would argue they've also arisen as majorities who now find themselves more in the minority with respect to seeing their religious beliefs about a particular conception of marriage no longer reflected in civil law. And in writing my book, Who's the Bigot, I studied the briefs in a number of these cases that came up before the Supreme Court, and you'll see some of these conservative religious groups basically arguing that the majority has a right to reflect its moral beliefs about what's right and wrong or good or bad in the law, and people believe homosexuality is immoral and evil, and they have a right to legislate against it. And now that Obergefell versus Hodges since 2015 has said that same-sex couples have a fundamental liberty right to marry, the position has shifted to saying that religious dissenters ought to be protected from an overweening government orthodoxy with which they disagree. And so that's sort of part of where that's all shifting. So what does religious liberty mean in this context, and how do we think about it in these very civic spaces? We're not, it's clear under the First Amendment that even though the various states allow same-sex couples to marry, they certainly can't compel a religious official to perform such a marriage, right? We don't need a law telling us that, because the First Amendment basically protects that. But what's not so clear is that the First Amendment means that someone who operates a business in commerce, open to the public, can simply say, my religious belief regards same-sex marriage as immoral and not a real marriage, and if I have to provide a good or service to this person, I'm going to violate my conscience and be complicit in sin, and therefore, even though my state says no discrimination on the marketplace based on sexual orientation, I should be exempted from that law so I don't violate my conscience. Now, one of the things that I've been very interested in is the analogy to race, right? Because there has been this notion that if religious believers are not allowed to be exempted from state anti-discrimination laws, you're basically saying they're bigots and they're as bad as racist. And in the Supreme Court rhetoric of Obergefell, 4 of the dissenters from Justice Kennedy's majority opinion basically said that he was branding traditional believers as bigots for holding on to their traditional conception of marriage. Now, Kennedy never utters the word bigot in any of his gay rights opinions, but nonetheless, it's read as saying that if these people are told that they can't act on their religious beliefs in law, then they are being treated as bigots. Now, what Justice Kennedy actually said is that we recognize sincere opposition to same-sex marriage, but when people try to put that into law and policy and put the state's imprimatur on it, the stamp of approval on it, it demeans same-sex couples, right? So that's what Obergefell actually says, but Justice Alito gives us some extremely dramatic language that's been quoted many, many times about how after Obergefell, people with traditional religious beliefs can whisper them in their homes, but if they dare to walk out the door and utter them in public and act on them, they'll be branded as bigots. And this relies on, in particular, notion that somehow the majority has branded believers as racist, and that somehow, you're saying that opposition to same-sex marriage is just as odious as religious racism. So in my book, Who's the Bigot, I spent a couple chapters looking at religious rhetoric about segregation in the 1950s and 60s, and I sort of showed the competing theologies of segregation and integration and how that led various religious denominations either to support Brown versus Board of Education, which said separate but equal is not equal in education, or how it led them to support or oppose the Civil Rights Act of 1964. But it is striking to see that religious groups kind of were on both sides of these matters. In the debate over the Civil Rights Act of 1964, a trio of religious leaders, kind of like the proverbial joke that ministers would tell, a rabbi, a priest, and a minister, all testified in support of the Civil Rights Act, saying that the religious conscience of America condemns racism as blasphemy against God and called racism a serious moral evil. They even opposed the so-called Mrs. Murphy exception that said if you just had a rooming house or a boarding house, you were exempt from, the public accommodation law. They thought that was terrible. They thought they should call her Typhoid Mary instead of Mrs. Murphy. At the same time, Dr. Albert Garner, who was the president of the Florida Baptist Institute and a member of the American Baptist Association's Race and Civil Rights Committee, said, quote, "Our nation became the greatest and most respected nation in the world under the pattern of segregation and social life," close quote, and quote, "Moral principles never change, and the segregation of the races in social and religious life is still of divine order." In fact, Dr. Garner said this trio of clergy were the moral blasphemers and immoral men who were like communists and heretics. In fact, when President Kennedy met with a number of ministers in 1963, urging them to form a biracial committee to support voluntary integration of business and to lend support to the Civil Rights Act, Garner admonished him that racial integration would lead to intermarriage, and that was against the will of the Creator. And if you look at the record of the Civil Rights Act, a number of opponents of the Civil Rights Act read into the record numerous statements from Southern congregations opposing the law. Some lay witnesses appealed to the divine order of segregation. One of my favorite was a businessman who claimed God himself was the greatest segregationist of all time. Now, admittedly, Mr. French would probably say this is a religious power, not religious liberty. But luckily, this religious power did not prevail because the Civil Rights Act was passed. But what if they had religious exemptions to the Civil Rights Act? Given the pervasiveness, particularly in the South, of a belief that segregation was of divine origin. A prominent ethicist, Thomas Maston, from the Southern Baptist Church, worried in 1955 when he faced the resistance that Southern Baptists had to desegregation, that a lot of Baptists would be, quote, on the wrong side of this whole issue, close quote. And he was right about the level of opposition to desegregation. And this opposition believed itself to be quite in the right and quite sincere. A study in Little Rock, Arkansas, of segregationist ministers reported one man's remark that, quote, as sure as I know my name, I know segregation is pleasing to the Lord, close quote. So if you had religious exemptions to the Civil Rights Act, what would have been the effect, given the pervasiveness in some parts to the belief that segregation was of divine origin, right? Or simple moral disapproval of racial mixing, or simple racism that you just didn't want to mingle with Black people. And so the Civil Rights Act did not have these exemptions. And when a restaurateur in the Piggy Park case claimed that the Civil Rights Act violated his religious liberty, the Supreme Court did not credence that argument. So I'm not saying traditional believers today with their views about marriage are like religious racists of the past. I'm just saying that I think it's too simple to say, oh, that has nothing to do with the issues we face today, right? And I think that in some of these arguments about religious liberty, there's a tendency to say, it's only religious racism that clearly should not be accommodated because it's so obvious that that's odious and government has a compelling interest in ending race discrimination. Whereas when it comes to LGBTQ discrimination, well, that's sincere and it's just like a culture war issue, and that should be accommodated. But then the question is, what happens to all the things in between? The court is hearing a case this term that Mr. French is very familiar with, called City of Philadelphia versus Fulton, which has to do with foster care contracting, where the municipality has an anti-discrimination law that says you can't discriminate against based on sexual orientation in government provision of government services. And Catholic Social Services Agency, that has done foster care work for quite a long time, will not certify same-sex couples as foster parents because of their beliefs about marriage. So in the oral argument, the justices are trying to sort out, okay, what do we do? Are you saying that a religious social service agency could turn away an interracial couple? Oh, no, no, no. Government has a super compelling interest in race. Well, what about an interfaith couple? What about this type of a couple? Or suppose it's a government contract to supply transportation. What if a religious contractor says, we have to segregate the sexes on the buses, or women have to wear head coverings? I mean, so they're trying to find what's the line. And I'd love to hear what Mr. French thinks the proper line should be if you're going to say people have to live out their faith, in all these areas of life. Is race just uniquely compelling, or are there other types of anti-discrimination protections that should prevail, even if someone says, I have a sincere belief in this area? So I better wrap up because I don't want to take too much time, but one of the principles of First Amendment jurisprudence is that religious accommodation shouldn't impose harms on third parties, right? And so I think that's a very important principle when you think about how are people going to occupy this shared civic space. Mr. French and I, like some other conservatives and liberals, disagree on the magnitude of these harms. For some conservatives, getting turned away at one bakery for a wedding cake, you could just go down the street and easily have another cake. On the other hand, experts on, excuse me, minority stress suggest that when LGBT people go out into the marketplace, they never know when they're going to experience discrimination. And this adds to this general level of stress that they experience. And so the last thing I'll say is I think it's important to put this issue in national perspective, because the majority of states right now do not protect persons against discrimination based on sexual orientation or gender identity. A significant minority do, Massachusetts, and I'm assuming Vermont. So to an image of religious liberty being under siege, it's important to have a realistic picture of the current state of anti-discrimination law. And a new study just came out that showed that since Justice Roberts became Chief Justice, plaintiffs in religious liberty cases have prevailed 81% of the time, much higher percentage than earlier periods. And unlike earlier cases involving minority religions, most of these cases involve Christian majority religions. And with Justice Amy Coney Barrett on the court, the percentage is likely to rise, as we've already seen with the flip the court has done on state restrictions on religious gatherings during the pandemic. So I'd like to put the question to the audience: what do you think is an ideal conception of the limits of religious liberty that's consistent with pluralism and with government's compelling interest in protecting people from discrimination in various areas of civic life, such as employment, education, and the marketplace? Thank you.
Thank you so much, Professor McClain, for those remarks. And you were economical as well, so we have plenty of time for questions. And of course, we always invite students to jump to the front of the line. So feel free to use the hand raise function, and Professor Winslet will call on you. And if you have a strong preference, I believe is it possible to put questions in the chat, or the chat is not operating?
The chat was not operating.
Okay, so
Professor McClain had sort of thrown a couple of questions at Mr. French. Should we give David a chance to respond real quick, or just go straight to Q&A?
Sure. Do you want to make do you want to answer the question that was posed, Mr. French?
Sure. So I've got just a couple of responses quickly. Number one, I think at a baseline right now, I think there's a broad consensus baseline that I would say at least has 7 justices. The Supreme Court, in certain circumstances, might even have 9, but definitely 7, that says that religion should not be treated differently and worse from non-religion in state action. This is one of the reasons why, if you look at the last 10 years of religious liberty jurisprudence on the Supreme Court, I believe it's almost a 15-case winning streak, with the vast majority of those being decided by more than 5-4, 7-2, 9-0, 6-3. And one of the reasons is in some of these cases that came up, the posture of the case is that the religious litigant was treated differently and worse than a non-religious litigant. A perfect example of this is for a lot of people, what was surprising in the Masterpiece Cake Shop case, and this is a case where a baker refused to custom design a cake for a same-sex wedding. He offered to sell the cakes that had already been made, but not to custom design a cake, under the argument that he did not use his artistic talents to advance messages that he didn't agree with. And it wasn't just same-sex marriage, it would be any number of other things that he didn't agree with. And the reason why the court ruled 7-2 for him was that they found that in the decision-making process, in the actual state process where he was being brought up on allegations that he committed an action of discriminated against the gay couple who wanted the cake, they found that he was actually treated, they targeted his religious beliefs pretty specifically in that process. And that's a no-no. And I would bet, I mean, I don't know if Professor McClain agreed with that outcome and Kagan and Breyer joining that. But I would say we probably have a broad probably a broad level of agreement that at the very least the state should not treat religion differently and worse than it treats non-religion. Now, where we're probably going to disagree is on the circumstances where how much of a thumb in favor of religious liberty does the First Amendment put, or how much does the First Amendment put a thumb in favor of religious liberty into our legal analysis? So, for example, in the Newman versus Piggy Park case, the Supreme Court, I think, rightly said that if you're just denying someone the ability to eat at your restaurant and you're claiming that's a religious liberty right, that's, I believe the exact quote was, that's patently frivolous. That's a patently frivolous argument that your First Amendment right to religious liberty is going to be so strong that it overcomes a generally applicable non-discrimination law that opens up, that's aimed to defeat Jim Crow and opens up a business to all comers. I agree with that decision completely. I don't even know if, it's hard for me to even think of a religious liberty advocate that disagrees with that decision. But then the question becomes, under what circumstances does the state interest overcome my religious liberty right that is articulated and enumerated in the Bill of Rights? And my argument is pretty simple. If the state interest is, if the state is trying to move into the sphere of a religious entity, whether it's a Catholic charities, like in the Fulton case, a church, a religious school, there the state interest is much diminished compared to a state interest in a secular space, like if you're running an insurance agency and you say, well, I'm a Christian running an insurance agency and I don't want to give benefits to same-sex partners. There's a stronger state interest in maintaining access, equal access to benefits. It's not one that can overcome any asserted religious liberty interest, but it is a stronger state interest than saying to a church, this is how you should handle your employee benefits. And so that's where I think when we're talking about the difference between religious liberty and religious power, I think of the Defense of Marriage Act, yes, that's an exercise of more of power, a moral statement through law. Religious liberty is much more of a defensive operation where power is being exerted on the religious entity. So that's how I draw a difference. I think there is a stronger state interest in overriding religious liberty in certain secular spaces than there is in religious spaces. Now, that doesn't mean that the state can never override the religious liberty interest in sacred spaces, in religious spaces, and that the state interest always overrides in secular. It's just that there is a different level of state interest in one versus the other.
Could I respond to that?
Sure.
So thank you, David. If I could call you David, and please call me
Sure,
Linda.
please.
So I just a couple of things. On Masterpiece Cake Shop, I just want to say that I think that the court was 7-2, that the commission had treated Mr. Phillips' beliefs with hostility.
Right.
What they did not decide, and I want the audience to understand this, what they did not decide was the merits, which was Colorado's, did Mr. Phillips have a First Amendment right to an exemption from Colorado's anti-discrimination law? And Justice Kennedy says, unfortunately, we can't even get to that because you treated him in a disrespectful way. Instead of treating him in a neutral, respectful manner, you treated him with hostility. So they didn't say that Colorado's anti-discrimination law manifested hostility to Mr. Phillips. And they said that has to wait another day. And what Kagan and Breyer said is, we just want to write a concurring opinion explaining how easy it could have been for the Civil Rights Commission not to be so boneheaded about it and to treat him in a respectful way and still reach the results that he had to comply with the law. So I just want to clarify, it's not exactly a 7-2 ruling in his favor with respect to whether he was entitled to religious exemption. It's that he was targeted or treated with hostility. Not the law itself wasn't held to be unconstitutional. And Justice Kennedy goes out of his way to say that it's unexceptional that Colorado can protect gay persons in the marketplace just like they can protect other protected categories. He kind of left it to another day, right? So then the one thing I'd like to ask about is, I'm interested in your picture of secular spaces, because what you describe as a secular space, like the insurance company is a great example. Some other people who defend religious liberty say, hey, when I walk out the door in the morning and I walk to my business and I open my business door, everything I'm doing is an act of worship. And as a secular business owner, I'm no less religious than a nonprofit religious group. I mean, so there are these, and the Catholic bishops have made these kind of arguments in their amicus briefs, right? So what do you say to people who say, I reject your line, Mr. French, between a secular space with the insurance agency, which might be subject to anti-discrimination law, and a more obviously religious space? Because I do believe there are people who are going to say, everything's an act of worship. How dare you tell me that my whole life's not a living testament to my religious faith?
Well, as an evangelical, every aspect of my life, I'm trying to live out my faith. It's not as if when I'm in church on Sunday morning, I'm thinking, now I'm being Christian. And then on this Zoom, I'm thinking, nope, not Christian. Although I've had, during the pandemic, many moments of temptation on Zooms where I didn't feel super Christian. But for somebody, a religious believer, the way they interact with the world is an expression of their religious belief, whether they are in a secular space or whether they're in a religious space. My issue is not, is that a religious, are you being sincere or not sincere in your expression of religious faith in these different spaces? It's how powerful is the state interest, okay? Because as we know from historically before Employment Division v. Smith, which I think of as one of Scalia's worst decisions, which really undercut the free exercise clause in a lot of ways. You had when your religious beliefs were burdened, the state could overcome that burden on your religious beliefs in furtherance of what was called a compelling state interest advanced by least restrictive means. And so there's always an understanding that there are state interests that are powerful enough to overcome an assertion of religious liberty. And so I'm not disputing at all the idea that somebody who is running an insurance agency and that same person teaching Sunday school, in both circumstances, is living out their faith. What I'm saying is that in the Sunday school example, the state interest in intruding upon the Sunday school is a heck of a lot less than the state interest in intruding upon the insurance agency. And so that's where the distinction lies. And this is interesting. And the Supreme Court is actually really tracking this right now, because if you look at, there's a couple of cases in the last term, the Bostock case, which was decided with Justice Gorsuch and Justice Roberts kind of unexpectedly, in a lot of people's eyes, switching over to joining the Democratic nominated minority to create have a 6-3 decision saying that under Title VII now protects LGBT Americans from workplace discrimination. At the same time, so that was 6-3 one direction. At the same time, there was a 7-2 decision, again, where Kagan and Breyer joined the then five on the Supreme Court who were nominated by Republicans to expand the scope of what's called the ministerial exception to non-discrimination laws, which says if someone has a ministerial function, they're a ministerial employee in a religious institution, non-discrimination laws don't apply at all. Not at all. So here you had this really interesting alignment where you had a critical mass of a pivotal mass of the Supreme Court going along those lines. It says, okay, in the secular space, we have enhanced the reach of non-discrimination law. In the religious space, we have diminished the reach of non-discrimination law. And that tracks right along with what I've been saying about the differing state interests.
If I could just say one little thing about that. I think Gorsuch's opinion was a remarkable opinion. And it was also like, he wrote it as such an exercise of logic. It's like, look, it just stands to reason that if you're discriminating against someone because of sexual orientation, that's because of sex, ditto gender identity. But Gorsuch also said the religious liberty issues aren't before us, and we leave those to another day. So, you know, the next 4 or 5 cases where the funeral home director says, look, like I did there, because of my religious beliefs, I can't recognize someone changing their gender from a man to a woman, and they have to follow the dress code and dress as a man, not a woman, and raises a religious liberty claim. Gorsuch said, we're not addressing that. It was raised below, but for some reason they didn't bring it up on appeal. So I do think, David, that it's not that simple, because there's going to be these inevitable cases where people are going to challenge, saying under Title VII, you know, you have to cut me some slack in terms of a religious exemption. Right now, my understanding of Title VII is there are not broad religious exemptions unless you're a religious institution, and you're talking about the ministerial exception. So, you know, who knows what sort of things Gorsuch is envisioning that might come up down the road.
I'm going to make a prediction, and so it's being recorded. So we at some point you can tell me if I'm right or wrong. But the more that the non-discrimination law applies to things like hiring, firing, does an employer have an ability, a secular employer have the ability to hire or fire somebody, even if they're religious, simply because they're gay or trans, or if you're talking about serving, you know, classic public accommodation? I don't think a free exercise claim is going to overcome that. The more it veers into the world of expression, such as the core of the Phillips argument in Masterpiece Cake Shop was not, I don't serve people who are gay. It was, I don't use my artistic abilities to send a message that I disagree with. That was sounding much more in First Amendment. Then he was not seeking a blanket exemption from non-discrimination law. He just wasn't. He was seeking to say that this was an act of compelled speech more so than it was a search for a blanket exemption from non-discrimination law. I bet that's where it's going to end up. We'll see.
All right, great. I think we'll move on to questions now. We got Pat Gunn first, followed by a couple more in line. Pat's here. Okay.
Howdy. So however we draw these lines, I think it's important that common people can understand the reasoning, even if they disagree, so that it can become part of our civics, and so that we're not fighting about it forever. So it's not just a question of how to get the lawyers to agree, but to provide something that everybody can internalize, and provide things that are conceptually magnetic. And so I guess I'd like to propose a potential line in the sand and hope that it's appealing, understandable, and workable with cases on our and lines up at least reasonably with some intuitions. And I'm curious particularly what David and Linda think about it. In terms of questions on what employers should fund, like healthcare plans, we already pay taxes to the government for a number of things that we don't approve of. It's the foundation for a lot of our society, and so I would suggest that maybe should be on the side of getting no exemptions. Likewise with non-specific performance, like selling pre-made things. But when it comes to specific performance, that sounds like an area where there's a conceptually appealing argument for considering that more of a compelled speech flavored thing, and as something where we might be willing to grant a number of broad or broad leeway to people whose creed would not have them express those things. Would that be workable as a legal and civic division between would that be workable as a line for this legally and in our civics?
Do you want to go first? Okay. Yeah, there's an awful lot of religious liberty case law stretching even back to Employment Division versus Smith, that has held, for example, that the request for a religious exemption from some of the big, broad sort of government requirements of our day, that those fail, even under the stronger religious liberty tests. So I'm thinking about, for example, the case of United States versus Lee in 1982, that religious beliefs couldn't preclude employers from their duty of contributing Social Security benefits on behalf of their employees. A person sought a religious liberty exemption from that. So we already have a pretty broad regime that says, okay, wait a minute, when you're doing these sort of big, the big programs like income taxes, Social Security taxes, things like this, that an absolute religious liberty right to exempt yourself from the operations of those things doesn't exist. And there's not many people who would really try to, undo that. I don't know of any move in sort of the religious liberty bar to do that. So that's already done. I think where we're talking now, if you want to talk about, and I hate to be a broken record, is that there's a couple of cases that a line that people can understand and a line that makes sense to people is a line that says, are you trying to alter the behavior and is the state interfering with the operation of a religious institution, or is the state interfering with the operation of a secular institution? That in those circumstances, I think that's a line that people can understand. That's a line that makes sense to people, particularly in the non-discrimination context. So that's one that I think is sustainable, and that's one that I think that people that is explainable enough to people that they don't have to be a constitutional scholar to understand that if the state is trying to reach into the operation of a religious nonprofit, it has less reach than if it's reaching into the operation of general commerce.
So thank you for that proposal, Pat. On the part about the taxpayer, Hobby Lobby, the Burwell versus Hobby Lobby case, which was decided a number of years ago, involved two for-profit, closely held corporations, Hobby Lobby and Conestoga Wood, where under the Obama presidency, Congress passed the Affordable Care Act, and the Affordable Care Act included a set of preventive services that must be included in health insurance, preventive services that women needed, and contraception was on the list. And Conestoga and Hobby Lobby, their owners, objected to several of the contraceptives which they believed functioned like abortofacients. In other words, they were analogous to somehow terminating a human life or something. And the court, applying the Religious Freedom Restoration Act, concluded that even though they were for-profit corporations, not religious corporations, they had free exercise rights, and they were substantially burdened by the Affordable Care Act's requirement that an insurer had to include these contraceptives, all FDA-approved forms of contraception, in a healthcare plan. And the court said, even though the state had a compelling, let's grant that there was a compelling state interest, a governmental interest in preventing and providing women with preventive health care, because contraception was often unaffordable for women, or the cost might be a factor of them getting it. The state had other ways to provide it, like maybe the government could provide it. Okay, so we already have precedents that say for-profit corporations are allowed to exercise their religious liberty in ways that disadvantage their employees. And during the Trump administration, Trump took it even further and signed an executive order saying any corporation that had a moral or religious objection to providing contraception for its employees didn't have to, right? So that's the first part of your point. So I wish the world was as David describes it, but I think people, maybe they recognize that line, but right now, for-profit corporations still have this kind of religious exercise argument. And in terms of the other interesting point that you made about specific performance and compelling speech. You know, when they had the oral argument in Masterpiece Cake Shop, which I urge you to listen to if you want to. These are available on the web. Masterpiece Cake Shop versus Colorado Civil Rights Commission. The justices were trying to explore this compelled speech argument that the lawyers for Jack Phillips, the owner of Masterpiece Cake Shop, was making. And there were some really interesting hypotheticals, because the argument was a baker who makes a wedding cake. It's very artistic. There's all this design involved. It's like a work of art. That's why he calls his business masterpiece. You know, he has a paint palette. And so especially the female justices like Kagan, Sotomayor, and Ginsburg were like, okay, what about a tailor who makes a beautiful set of clothes? Is that artistic expression? Should they be exempt because you violate their artistic expression by making them create this suit of clothes? What about a hairstylist? What about a makeup artist? And the lawyer is saying, oh no. And they're saying, wait a minute, makeup artists are making you beautiful for this day? Or what about the chef who prepares the special meal for your wedding or your anniversary? So they went through a whole bunch of hypotheticals saying, you know, what about and Breyer said, what about an architect? And the lawyer said, oh, well, that's just a building. Are you telling me an architect is less creative than Jack Phillips? So it was kind of, but Breyer basically said, look, we are trying to get you to tell us what is a line that you can draw that keeps from undermining all these civil rights laws. Tell us the line of creative expression. Where is it drawn? So I think that's one concern, trying to figure out what is the line in terms of when you're compelling expression. Is it making clothes? Is it cooking food? Is it doing makeup? Is it doing hair? Is it building a building? Is it booking travel? I mean, what is it?
Okay, I think we'll go to Nigel Schilling next.
Hello. Thanks for both of you guys. This talk was wonderful. Professor McClain, I really appreciate your point about kind of the earlier point about the coexistence of like secular and non-secular spaces, especially in like pluralist societies. And I think for this reason, you know, there are often like clashes between like religious liberty claims and laws barring discrimination based on sexual orientation or gender identity, for example, as is the case in Fulton. And I like the question you asked earlier about like to Professor French about how you envision like these shared spaces. You already answered that. So like I'll kind of further that question directed towards Professor McClain. And if you could probably answer it specifically in relation to the Fulton case, that would be interesting for me because I did a research project last semester about it. And I was wondering what level of scrutiny you think courts should apply to like government actions infringing on religious exercise. And a question for both of you guys, I guess, could be also like, are you guys at all concerned about like a potential removal of a state's burden to satisfy strict scrutiny having like a very highly undesirable effect of like generating legislative indifference towards religious liberties? You know, like, are we kind of heading towards, you know, like a society where like the evolution of rights in one area kind of infringes on the rights of another? If that makes sense.
Nigel, could you just use your sense that there's a risk that the court is going to impose too lax a burden on the state?
Yes.
So there'll be too much infringement on religious liberty?
Correct.
Okay. Okay. So, you know, as David said, at the moment, the Smith case is the relevant law, right? And you did your research paper, but for people who may not know, this is a case in which 2 employees were fired for using peyote, and they claimed it was due to religious observance. And Justice Scalia basically said this was a neutral law of general applicability. It wasn't singling out any particular religion, and therefore it was upheld. And he also said that when you've got a generally applicable law, you don't need to satisfy a compelling state interest test. Now, the dissenter said, oh, this is outrageous, you're departing from our jurisprudence. But Smith basically, you know, has been kind of the law. But as David also said, if you're targeting religion or singling them out for special hostility, then you have to move to the strict scrutiny test. So one of the issues in Fulton, as you probably know, Nigel, is should the court abandon Smith? because in the oral argument, the lawyers for Catholic Social Services Agency said that Smith is wrongly decided, and it's time to have a more protective approach, so that even if you're not targeting a religion, you always have to show that if there's any burden on religious exercise, a compelling state interest and no less restrictive alternative. Now, I'm generally not a big fan of Justice Scalia, but I do think that in Smith he made a couple of good points. And one of them was, if the state has to satisfy a compelling state interest for every time that a civil law puts some burden on religion, there's going to be all sorts of objections to all sorts of laws, and every person basically will be a law unto themselves. So the practical question is, how do you have peaceful coexistence if there's such a high burden on the part of the state when they have generally applicable laws? And I think that's sort of the, I don't know what the court, I don't know if the court's ready to overrule Smith or not. But that would certainly, that would have the effect, Nigel, of making it more likely that there'd be greater protection of religious liberty and more challenges to state laws, and maybe fewer state laws would be upheld. I'm not really sure how that would go.
I would be surprised, based on the oral argument at Fulton, if the court used Fulton to reverse Smith. I honestly think that as they were working through the oral argument, it was as if they were understanding that this was not the vehicle to reverse Smith that they thought it was. I think that what you're more likely to see, and what you have seen in some of the pandemic cases, is a narrowing of Smith. That and the way you narrow Smith is you broaden the comparators.
Mm-hmm.
So, for example, in the most recent Supreme Court case involving home gatherings of a California regulation that prevented religious gatherings of more than 3 households, under what I would call maybe a more Scalia like reading of Smith, that would have passed muster. Why? Because gatherings of 3 or more households were prohibited across the board in California. Under a reading of Smith that is narrower, what the court has done is said, wait a minute, we're going to compare a lot of things. So, for example, nail salons or stores where you're going to be in close proximity to each other for a while, which are all allowed. So you have this kind of gathering that's allowed outside the home that the court judges to be very similar to the gathering allowed inside the home. So therefore, these are not being treated the same way. So we're going to apply strict scrutiny. And so I think that's the future. I could be wrong about that. I would be surprised if the court used the Fulton case to overrule Smith. I think that what the court is going to do is what it's done with a lot of doctrines that it doesn't like. It doesn't exactly overrule them. It just narrows them down to meaninglessness. So, for example, one doctrine that's like that is what's called the Lemon test in Establishment Clause cases. That the Lemon test it's just a zombie doctrine at this point, and it's even less dangerous than your average zombie. It just barely exists at all. So I think that what's happening is that the court is slowly moving. I didn't like the Scalia case. I did not like the Scalia decision in Employment Division v. Smith. Because what I feel like it did is it took the free exercise clause and it placed it in a subordinate position in the First Amendment. It placed it as a less potent doctrine than, say, the free speech clause. And the text and the history don't, I think, permit that reading of the free exercise clause. Now, why would Scalia do that as a noted originalist? Well, what's interesting, if you look at the facts of the case of the Smith case, and Professor McClain went straight at it, it was a drug case. It was involving a hallucinogenic drug, peyote. And if there's one thing that you learn when you start to read through constitutional law cases where it feels like, wait a minute, this doesn't seem right. This seems to grant the state too much power. An awful lot of the time, you go into the facts and it's a drug case. It's a war on drugs distortion. again and again. You see it in Fourth Amendment, you see it in Fifth Amendment, you see it in many circumstances where you see it in free speech. There's a famous case involving student speech called Morse v. Frederick, where when the Olympic torch was passing outside of school, a kid outside of school unveiled a giant banner that said "Bong hits for Jesus."
Right.
Didn't disrupt anything, didn't do anything, but he was punished for unveiling that banner. Well, I guarantee you, if it said "Jesus saves," he'd have won that case. Guarantee you. But it said "Bong hits for," nobody even knows what that means. What does "Bong hits for Jesus"? Nobody knows. It's a joke. But because it touched on the drug war issue, it became an outlier in First Amendment jurisprudence. So that's one of my beefs that I have with Employment Division v. Smith. I think it's part of the drug war outlier where other constitutional liberties were inappropriately suppressed in connection with this sort of overriding imperative to deal with drugs.
I mean, I think another thing that might be going on with Smith is Justice Scalia might have felt differently about peyote using Native Americans than he did about evangelical Christians. And so, if majority religions are being squeezed, it's interesting. When Smith came out, the liberals were all in the dissent, right? And they were kind of worried about the impact on religious liberty. And as time has gone on, and as you know from your exchange with Marcy Hamilton, there's a great recognition that Smith is a good rule because it puts some limits on religious institutions when they might be harming other people, right? Like child sex abuse in the church and things like that. And so there's been more embrace of Smith, I think, by liberals and progressives, and more criticism by religious conservatives over time. So it's kind of flipped, I think, in terms of how people feel about it.
When I was in law school, I was interested. So I got into law school in '91, and the number of people, the religious liberty bar could fit in a phone booth. It was such a small, and Smith had just been decided, and there was bipartisan outrage against Smith amongst members of the religious liberty bar. But the religious liberty bar and those focused on religious liberty, it was a very, very small group of people, in part because almost all the religious liberty cases that came to the Supreme Court prior to Smith were involving minority religions. Why is that? It goes back to that issue that I said before. The white Protestants had religious power.
Right.
They had power. So you don't need liberty when you have power. And so you need liberty when you don't have power. And so this is one of the reasons why you've seen a lot of alarm from evangelicals, for example, over the last 25, 30 years, is they're making religious liberty claims that they've never had to make before because they controlled the levers of power. And then so therefore, that's why a lot of these cases have flipped. But at the same time, they keep winning. So there's this huge win streak. And the way I've put it is in a piece I wrote some time ago, that the citadel of religious liberty is very high and strong right now. You have more religious liberty protections at this moment in America, concrete religious liberty protections at this moment in American history, I would say, and I'd be interested to hear if you disagree with Professor, right now than at any time in American history, even with Employment Division v. Smith. But at the same time, you have individuals who are seeking to knock down that citadel. So at the same time, you have a high citadel, but the cannon fire against the citadel is very real. But I think the prospect over the short term is that citadel will get stronger with the current court, not weaker, even though it's receiving incoming fire.
Well, I was accidentally on a conservative email list about that was telling me the absolute urgency of getting Amy Coney Barrett approved to the court because religious liberty was under threat. So rhetorically, I think they used the threat of freedom of religion as a way to warn conservatives they have to support all these causes and reelect Donald Trump and the like.
Well, there's a lot of activist groups who act as if there has not been a single victory for religious liberty in the last 15 years, when I can only think of one real loss, meaningful loss in the last 15 years, and no real losses in the last 10 years. So,
well, don't you think they think Obergefell was a major loss?
Well, it doesn't. Obergefell on its terms was not a religious liberty case. It was a
But-
loss in the sense of Bostock, in that the belief was it would empower additional threats to religious liberty. But at the same time, there have been a series of significant religious liberty wins since that time, since Obergefell and since Bostock.
Right.
And so on the one hand, they're right to say there are non-discrimination laws have created threats to religious liberty. At the same time, they have largely fended off these threats to religious liberty. So that's why I say two things are happening at once. There's the cannon fires coming in, but the walls are not just holding, they're getting stronger with each case.
And may I just say a small thing to the students? I want to make clear that in all these major controversies over LGBT rights, religious organizations have filed Friends of the Court briefs on both sides of the issue. So it's really important to make sure we don't think that religious liberty always means opposition to anti-discrimination law, or there's always going to be a claim that liberty is threatened by extending anti-discrimination law, because, you know, I've read the briefs in all of these major cases, and, you know, there's always going to be a big omnibus brief filed by the Catholic bishops and, you know, the evangelicals and blah, blah, blah on the one side. And then there's going to be a big brief filed by the United Church of Christ and the Methodists and these other groups. And so it's very striking how religious organizations and leaders have weighed in on both sides of these battles. So we shouldn't act like it's always going to be, there's only one position on whether religious liberty is threatened or not. And this was the same was true in, like I said, in the battle over the Civil Rights Act, right? So I think it's important to recognize that religions are not monolithic. You know, they have a wide variety of issues, and sometimes it causes schism. Look at the Methodists and their disagreement over same-sex marriage, right? I mean, religion, and during the 50s and 60s, religious groups broke apart, and before that over segregation, and before that over slavery. So there's not one monolithic religious view, and I think it's very important. And different religious people have different understandings of what the right balance should be about civil law and religious freedom.
Okay, we will go to Hannah Wander next.
Hello, so thank you so much, both of you, for doing this. So my question is mostly for Professor McClain, but either of you can answer. So you've both been talking about employment division versus Smith. And one thing I wanted to point out about the employment division versus Smith is something that you both mentioned a little bit, which is the disparate impact on minority religions. And most of the discussion in this seminar has been more about, you know, the idea of religious liberty impacting the anti-discrimination laws and that kind of thing, which is mostly a Christian thing with majority religions. And even when Professor McClain was mentioning the amicus briefs on both sides, you're still mentioning mostly well-known religions because you're mentioning mostly Christian denominations. And one thing that it happens when there's Smith, and one reason why people have argued against it, is because when you have minority religions that are unknown and they have no protection against generally applicable laws, the generally applicable laws are naturally more likely to affect them, just because since they're unknown, they're not going to have a voice to argue against the laws as they're being passed. And even when people pass things like anti-discrimination laws, people don't normally pass them without knowing that they might have a conflict with, say, like the Catholics or the evangelicals, which is not to say that these laws are wrong given that conflict. It's just to say the conflict is known beforehand. So given that, Professor McClain, you've argued more in favor of Smith, what would you say would be the path forward for religious minorities trying to fight for religious liberty under Smith, given that they tend to be more disparately impacted by the just generally applicable laws that Smith doesn't want to overturn?
Hannah, thank you for that question. I should have mentioned that. I mean, I should also, the major branches of Judaism have also filed briefs, and you know, some Islamic groups have also filed. There's been some Hindu groups that have filed. So it isn't only the Christian groups by any means. So I'm sorry if I gave that impression. But to your substantive question, you know, you may be familiar with the the Hialeah case that targeted Santeria, they drafted a law about killing animals that didn't mention Santeria by name, but clearly the good people of Florida didn't like the way that that ritual killing was done because of this religion. And the Supreme Court held that they had targeted this religion, right? And that was on, therefore you needed a compelling state interest, and it wasn't satisfied. In terms of what rule would help, I mean, I would say that anti-discrimination laws typically include religion as a protected category. So minority religions, on the one hand, should get some protection under these generally applicable non-discrimination laws if you're discriminated against, say, because you're a Wiccan or something, or because you're a Baha'i, or because you're, well, to go all the way back to Barnett, a Seventh-day Adventist or something. But I guess, is your concern that maybe these non-discrimination laws would somehow come down more harshly on minority religions? I mean, what's your concern?
Well, so I can't remember the specific name of the case, but there's one case example of a religion where it's considered, if you like destroy or desecrate the body after it's dead, then the spirit will not be able to go to the afterlife. And the family of someone who had been given an autopsy against the family's will basically sued based on this, and the judge, this was actually right after Employment Division versus Smith, was going to decide in their favor, and then switched his decision because he thought under Employment Division versus Smith, the autopsy law, since it didn't impact them, like it wasn't directly, and I understand, I am familiar with like the leukemia case that you're mentioning, but so like it's the fact that like that is a directly targeted case, even without specifically mentioning the religion, is more rare in these cases.
So do you think it would be better to go back to a strict scrutiny type of test then, like David French believes?
Yeah, I mean, I am pretty much with David on Employment Division versus Smith. Yeah.
Hannah, I knew you were a person of taste and refinement. I could just tell. I
don't like the comics though, so I'm not with you on everything.
Oh gosh, come on. One area where I think where you have seen powerful, one area, for example, where I think that you have seen the difficulty of being a person of a minority religious faith is in institutionalization settings, in prison settings. It's one of the reasons for the Religious Land Use and Institutionalized Persons Act, is there you have often a limited number of, for example, chaplains who are from almost exclusively a dominant, the majority religion. You have people who are incarcerated who are often from minority religions, and they find themselves seriously disadvantaged. And it's interesting, if you want to go back, this is something that's kind of counterintuitive. If you want to go back and ask yourself who was the best president for religious liberties in the last 50 years, the answer is actually quite surprising to people. I believe the answer is Bill Clinton. He signed the Religious Freedom Restoration Act, which in its original scope essentially overturned Smith. The Supreme Court narrowed its scope to just apply to federal laws, and then it also signed the Religious Land Use and Institutionalized Persons Act. And that is something that's been used. Again, this is something that enhanced religious liberty protections beyond what the baseline floor of the Supreme Court, and has been used again and again to protect minority expressions of religious faith, or expressions of minority religious faith in places where people are at their most disadvantaged when it comes to power. And I think that's I think that's a very just law, and it's a law that only really became necessary because of Smith. And it's yet another reason why I think that Smith was wrongly decided. And it's not as if that prior to Smith that, and that this is another thing that was interesting to me about the Scalia and Smith, is that it was not as if a robust religious liberty protection regime was creating chaos in American life. It wasn't interfering in any real meaningful way with the growth of the regulatory state, with the growth of the safety net. It was not at all. We were living, and it didn't even interfere with the growth of non-discrimination law. There was this effort in Newman versus Piggy Park that we talked about. So where the Supreme Court slapped down this religious liberty effort to try to get a blanket exemption from race discrimination laws. So we had a world in which strict scrutiny existed with non-discrimination law. And again, you know, I love Justice Scalia, but nobody's perfect. And he was not perfect on that case.
I know we're about out of time, but Hannah, I just was thinking about the travel ban case, Trump versus Hawaii, which I think was wrongly decided. And I agree with the Sotomayor and Ginsburg dissent. But there, Trump had made all these anti-Muslim statements, which people quoted George Washington saying to bigotry, no sanctions, saying, you know, he's making all these anti-religious statements about this particular religion. But Roberts managed to say, well, yeah, but nobody's perfect. And besides, there's national security reasons for this law. So that was coming right after coming before Masterpiece Cake Shop. One might have hoped that if you're going to be that sensitive to rhetoric, you know, you would apply the same standard in that case as well. But unfortunately, the court didn't do it.
Well, we're past 6:15. I think we could keep going, but we're past 6:15. Thank you both so much. This was a very lively exchange, a genuine exchange, I think, which is the goal. So thanks everyone for coming, and thank you to Professor McClain and Mr. French. Have a good evening.
Thank you.
Thank you.